Good morning. My name is Erwin Chemerinsky, and I have the great pleasure of being the Dean of the University of California, Berkeley School of Law. And it's my pleasure to welcome you to this conference that deals with issues concerning the courts in operating in a pandemic. I know that no one comes to any conference, whether it's online or in person, to hear the Dean's welcome. So I promise to keep my remarks very short so we get to the substance of the program. But I'd be remiss if I didn't extend some thanks to all who are making this possible. An enormous amount of planning and effort has to go to putting a conference like this. I want to start by thanking RAND for sponsoring this with us and working together to put this on. Such an enormously important topic, and bringing together the expertise of RAND with our Civil Justice Research Initiative is a wonderful collaboration. And I look forward to many such collaborations in the future. I want to take a moment to thank all of our speakers and panelists today, which are tremendously busy, and I'm grateful to them for taking time from their schedules to be part of this discussion. Most of all, though, I have to thank Ann Bloom, who's the Executive Director of the Civil Justice Research Initiative. Ann has worked tirelessly on this program, tirelessly she always does, to make everything for the Civil Justice Research Initiative such a success. CJRI was created several years ago to have a university-based program that looks at access to justice in the United States. Our goal is to bring together judges, practitioners, academics to look at the important cutting-edge issues. That's exactly what we're doing today. We're bringing together eminent jurists, lawyers, scholars to think together with regard to the challenges that are facing the courts because of the pandemic. There are so many hard issues. How should courts conduct their business in the midst of a pandemic? Can there be jury trials while COVID-19 is still spreading? How can courts manage their caseloads in light of COVID-19? When we think about civil justice, there is such a backlog developing with regard to criminal cases and the constitutional requirement for speedy trial. How will we ever be able to have civil trials and civil proceedings be able to go forward? We're in the midst of the worst economic depression since the 1930s. This is going to create enormous issues with regard to access to justice. How do we manage these access to justice issues in the courts? It's all of this and so much more that's been discussed in today's program. So I welcome you to the discussion. I thank all of you for attending, and I know we'll learn so much from listening to the panelists and talking with them over the course of the day.
Thanks, everyone.
Thank you.
I'm James Anderson, the director of the RAND Institute for Civil Justice and the Justice Policy Program at RAND. I want to thank you and Ann for conceiving this program and reaching out to us. I also want to thank Nick Pache, Kat Cruz, and Bethany Saunders Medina for all their hard work in organizing the conference. And I want to thank all of our panelists who devoted time today to sharing their insights. Finally, I want to thank Sue Steinman and the Habush Foundation for supporting this conference. Like Berkeley Law School, the RAND Institute for Civil Justice has a long history of conducting research that improves the civil justice system. And like CJRI, we're focused on improving access to justice issues. From our early research on jury verdicts to Deborah Hensler's seminal work on claiming behavior to more recent work on access to justice, we've really leaned on the wisdom and experience of our distinguished board of advisors, who can also often observe what's happening on the ground before the research community even becomes aware of it. So today, I'm hopeful that our work will really accomplish three goals, and I guess I urge folks participating to think about these goals over the next few hours. First, of course, I'm hopeful that it will help the courts cope with COVID today and the civil justice cope with COVID, and identify, if not best practices given the circumstances, at least good enough practices, so that the civil justice system continues to function as well as it can. Second, I hope that we can really identify practices that build resilience for the future. Even after COVID is a distant memory, I think courts and the civil justice system will face a variety of challenges and disruptions from natural disasters and other causes. And then finally, and this may be utopian, I'm optimistic that COVID can serve as a catalyst to improve the civil justice system more broadly, and help us all as lawyers identify practices that perhaps we've clung to unnecessarily as lawyers and judges, and identify things that are just that we no longer need, and then we can get rid of and improve the civil justice system and improve access to justice in that way. So finally, thank you. And with that, I'll hand off the baton to MC Sungaila, the chair of the ICJ Board of Advisors, to offer her welcome and thoughts. MC?
Thank you so much, James. As James mentioned, I am the board chair of RAND's Institute for Civil Justice Board of Advisors. I'm also a chair of the Appellate Practice Group at Buchalter in California. So on behalf of the board, welcome to this thought leadership event held jointly with Berkeley and its Justice Research Initiative. We are grateful that all of you, practicing lawyers, judges, policymakers, members of the public, are here with us today live or viewing the recordings of these panels in the future. In my decade-long tenure on the RAND board, RAND has partnered with several academic institutions, including Stanford Law School and UCLA, to analyze developing areas of the law and law practice, from the globalization of litigation to class actions, litigation funding, state court budgeting, and even attorney wellness. We're pleased to partner with Berkeley today on this equally timely and cutting-edge program, focused on both the short and long-term impacts from COVID and its reverberations. Our program today, to my knowledge, is the most comprehensive examination of COVID-related court issues to date. Our panels of judges, lawyers, RAND researchers, and academics will identify and guide us through the developing issues incorporating RAND's signature, objective, nonpartisan analysis. From jury trials, discovery, court dockets, and constitutional concerns to the potential longer-term impact on how we decide disputes, what court rules might need to be changed to facilitate this, remote hearings and trials, and how access to justice concerns might factor into our approaches going forward. So it's quite a comprehensive day. We will start with our first panel, which will begin in a moment, and we'll focus on the implications for civil juries. So sit back, lean forward, dive in, and enjoy the programs today.
Thanks, MC. And I think our next panel will begin in just a moment with Richard Jolly taking over.
Good morning. I'm so thrilled to be here with everyone. The panelists that'll be participating in the jury discussion, if you could turn on your videos. We're going to be getting started a little bit early, so a few of our panelists might be jumping in still. In addition, I know that there's been some Zoom problems, so hopefully our audience will be coming in as well. But first, as I said, my name is Richard Jolly. I am an associate at Susman Godfrey in Los Angeles and a research fellow for the Civil Justice Research Initiative of UC Berkeley. I'm really thrilled that the RAND Corporation and the CJRI have organized this fantastic conference, and specifically this conversation on the impact of COVID-19 on the court's ability to conduct jury trials. This is an issue that is close to my heart as a practitioner and as a scholar, and I know it is one that is close to the hearts of our panelists. And so I'm very pleased to introduce and to moderate the discussion amongst the three panelists that we have with us right now. Arturo J. Gonzalez is a partner at Morrison Foerster in San Francisco. We also have Professor Valerie Hans, who's the Charles F. Reichlin Professor of Law at Cornell Law School in New York. And we have Judge Carolyn Kuhl, who sits on the Los Angeles County Superior Court. We are also expecting Robert Clifford, who's the founder and senior partner of Clifford Law Offices in Santa Monica, California, and hopefully he'll be able to join us shortly. Our conversation on the importance of the civil jury will really proceed in three parts. First, we want to discuss and introduce why are we talking about something like civil juries in the middle of a global health crisis, as a public health crisis. Why is it important that we talk about the civil jury now, perhaps more than ever? Second, we're going to talk about how exactly the court's ability to conduct jury trials have been impacted by COVID-19 and the steps that courts have taken to address the practical and logistical problems posed by the pandemic. And finally, we're going to talk about what we can look to toward the future, talk about ways we can look at the civil jury perhaps differently, or how COVID-19 might change things more permanently. Throughout the conversation, I invite the audience to submit questions through the Q&A feature at the bottom of the Zoom. We will also be leaving time for questions at the end. So with that, I'm happy to get going. And to start, I'll start with the first question that I posed. Why should we be concerned about the civil jury during a pandemic? Valerie, could you speak to that?
Well, trial by jury is an important democratic institution, and we are losing a lot by pausing jury trials. First of all, we're losing the work that juries do. Juries spend time throughout the nation resolving disputes, big and small, and applying the law and contemporary ideas of justice in their decision making. So we're definitely losing that, but we're also losing the impact on juries. One of the things that research has shown is that participating on a jury is, for most people, a largely pretty positive experience. People are involved in actually doing justice instead of just sitting back and watching TV shows about other people doing justice. And that direct experience with other citizens in the resolution of societal disputes leads jurors to come away with more investment in society and also a more positive view about the courts and law itself. So we're losing that impact as well. And finally, one of the things we're losing is what is now been shown to be a democratizing effect of participating on a jury. Researchers, including myself, have looked at participating on a jury and how it affects subsequent actions on the part of jurors. And one of the things we've learned is that it increases people's willingness to participate in other social activities and political activities like voting. So it's a democratizing institution. We're losing its work. We're losing this positive impact in a time in the pandemic, where all of us are isolated. This is one of the institutions that has helped bind us together as a society. So that's what we're losing. I think it's a lot.
Some might say that the civil jury it's very unique to the United States at this point. We're one of the few countries that still uses civil juries to resolve the majority of its private disputes that aren't settled or forced into arbitration, et cetera. But legally, we can resolve our disputes through the use of the civil jury. Other states, other nations around the world that used to use the civil jury, including England, Great Britain, who sort of the great well of our jurisprudence, have largely abandoned the civil jury. What would you say to people who think, well, maybe this is just the time. This is the end of the civil jury here in the United States, the pandemic. Other countries have abandoned it. Maybe it's time for the United States to do the same.
Well, so you're absolutely right. There's been actually a tremendous decline over the decades in the proportion of civil disputes that are resolved by the civil jury. And I think later on in subsequent panels, we'll be talking about those kinds of issues that have forced things into alternative resolution approaches as opposed to the civil jury. But I still think the jury has a chance to reach very significant decisions in other cases that it decides. If you think about it, civil cases involve not only the application of the law, but also the application, really the infusion of societal views, some of which are changing. And we have different views today about the responsibility of ourselves and the responsibility of businesses toward people who use products or indeed employees. We have a new kind of understanding about how discrimination can occur in a whole variety of locations and juries bring this new understanding to the resolution of, for example, employment discrimination disputes. And so when you think about what civil juries do, again, in some very significant cases and some pretty ordinary cases, juries give us a chance to update people's views about what constitutes appropriate and responsible behavior as citizens. So that's why I think it remains important. It can also serve as a signal, a benchmark, if you will, for all those other cases that are resolved through other means.
So just to jump in for a minute, I am a trial court judge sitting on the Superior Court of California in Los Angeles. I'm happy to be on the board of advisors for the Institute for Civil Justice for RAND. And one of the great gifts, I think, of this conference is to bring together, as Dean Chemerinsky said, judges and lawyers together with the academy, because we can reinforce one another in many ways. And what Valerie has said about the empirical work so well fits with what we believe we observe here in the courtroom. As everyone knows, Los Angeles is a very diverse city, and that diversity is reflected in our juries. And one of the great gifts of being a judge in Los Angeles is to see that diverse veneer come together and work together on a jury of 12 people, and to really see people put aside in many ways their backgrounds and come together as a group and be very serious, in my judgment, about the jury instructions and the law, and try to do their duty according to what they're told. The other thing I would add is that with respect to fact-finding by juries, in my judgment, again, as over 25 years of watching juries work, I think they're better, the 12 of them, than any one judge would be in terms of assessing credibility and assimilating facts. When lawyers talk to them afterwards and report back to us, it's quite amazing the detail that they see, because each of them is looking individually at the evidence and then coming back together again in the deliberations to bring their individual observations together. So it is indeed a wonderful institution to be preserved.
That's so interesting, Judge. You know, one of the things that you said about LA being a diverse society, a diverse community, one of the things that we have learned through doing research is that a jury that represents a broad range of views is actually a very strong fact finder, in part because people who don't share the same assumptions as you test you when you make claims that might not be able to be supported. And so I guess here is another example in which your observations do reinforce some of the research on what makes the jury such a sound decision maker, even though it's often confronted with pretty complicated litigation.
And your observation about the impact of the service on the future for those jurors is also very interesting, because our experience is that people who have served on juries have a very positive attitude toward jury service most of the time. And as compared to people who, for example, maybe are called to jury service, but for whatever reason sit in the jury room for a day and go home, or participate in voir dire and are not selected. And that looks like a waste of time to them. But those people who serve mostly report back that they valued the experience.
Arturo, as a practitioner and as someone who has tried jury trials, what do you think is at stake here if we risk losing the civil jury?
Well, actually, I want to back up just one little baby step and make this point, and it is responsive to your question. I think it's very important for the audience to understand how critical this is to our democracy and where it comes from. If you ask high school students, college students, maybe even law students and lawyers, many of them don't know that the right to civil jury trial is in our Constitution. It's in our Bill of Rights. And I want to give you just a minute or so about why it's there and how critical it is. When we were having our disputes with the king way back when, in particular involving taxes, we had juries. The colonies had juries. And those juries began to rule against the king in cases involving taxes in particular. And the king got very upset and said, fine, we're not going to have juries anymore. We're going to have bench trials. And guess who appointed the judges? It was the king. And that was a significant part of the dispute that arose between the colonists and the king. When we wrote our Constitution, originally, the Bill of Rights that was drafted did not have a right to jury trial. Because some people were concerned, well, wait a minute, the juries are going to nullify the laws just the way we did when we tried to nullify the tax laws. And so some didn't want there to be a right to jury trial. But the Anti-Federalists insisted on including the right to civil jury trial in the Bill of Rights. And so ultimately, James Madison drafted it, and it was, in fact, in our Constitution. So that's where it comes from. It's part of our Constitution. And to put it into context in terms of how I use it, largely my work involves representing one big company against another one. But I've tried 12 civil rights cases. Section 1983 cases is a federal statute. And here's what I say to juries that I think is directly responsive to your question. I explained to them a little bit about the history of the Bill of Rights, how we had a constitutional convention and came up with the 3 branches of government. Then we had another one to determine what rights the people would have, and we call that the Bill of Rights. In my view, the most important document in this nation's history. And I say, and I talk to them usually about the 4th Amendment, because in excessive force cases, it's the 4th Amendment that matters. But what I say to them is, what do you do when law enforcement does something and a citizen claims that it violated his or her constitutional rights? You don't file a grievance with the president or with your governor. You have to go to federal court and you file a lawsuit. And then who ultimately decides whether or not the officer's conduct was proper? Again, it's not the president, it's not the governor, it's not the judge in this case. We're in the road. Who decides whether this is acceptable conduct? It's you. And I look right at them. I say, it's you. You're going to decide on behalf of our society whether it's appropriate for an officer to put his knee on someone's neck for 8 minutes. You're going to decide that. You're going to decide whether that was excessive force, because that is in our Constitution. That is what's at stake here. That is what is so important. I cannot think of a better way to arbitrate that issue that I just mentioned, or others like it. I don't like bench trials with respect to the judge and every other judge in America. They do a great job. I prefer juries. I don't want any one person resolving a dispute that I'm involved in. I'd prefer to have a group of people get together, listen to the evidence, listen to the law, and then make a decision. And that is what is at stake here, because that is what is now being jeopardized by COVID.
You know, I really like Arturo Gonzalez. I really like what you're doing with juries and telling them about the history of trial by jury. It's really fascinating, and it underscores actually another value of the jury trial, which is it has an educational function. Even if not everybody gives a brief history of trial by jury, still you're educating people about what actually does go on in courtrooms. Many of us, I love courtroom dramas and TV shows and movies that depict courtrooms, but obviously they're somewhat unrealistic, and it's often very eye-opening to go to an actual courtroom and see real judges and real lawyers and real witnesses and real scientific evidence and other kinds of things that are in typical disputes, and get a chance to see justice in action and actually be a part of it. So the educational function and the way it really allows us to learn more about key democratic institutions can't be underestimated.
Well, then it really seems like the question is precisely backwards. It's not do we need civil jury trials during a pandemic? It's that during a time of public health crisis and social unrest, that's precisely when we need civil jury trials. And that's right now what's so important and what is at stake. With that said, the pandemic obviously poses logistical and severe public health issues with inviting people from the community as we are trying to maintain social distance and to ensure the health of our communities. So I wanted to sort of shift gears and start talking about how has the civil jury been impacted by the pandemic, talking about those logistical and practical problems. And Judge, you're on the ground, so perhaps you could speak to what you've been seeing and how courts in Los Angeles are, how is jury selection being impacted? How has the crisis maybe affected the yield, the type of people who are reporting on those types of issues?
So we're just beginning to understand these things because we have only begun on our court. Only in July did we start sending summonses out, and only about 3 or 4 weeks ago did we start the first criminal trial. There are restrictions on what we can do that are inherent in trying to operate during these times. The most severe of which is that our courtrooms are only the size that they are. And with social distancing, there is only so many people that can come into that courtroom. And so, for example, I have one of the larger courtrooms in our 38 courthouse county. We are the largest trial court in the country. We have 38 courthouses and 550 judges. So it's massive in one sense, but I can only fit four people in my jury box. And therefore you're going to have to do something else. So we'll talk in a little bit about what some of the creative judges around the state have done and what their experiences have been. But I think just at the outset, it's important to say there's a restriction with regard to physical space. And then there are material resources restrictions in terms of, for example, the federal court in San Diego supplied clear masks to the jurors. Where are our resources to do something like that? They also fed them at lunchtime so that they didn't have to, go through the doors of the courthouse again, mix with other people, go out on the street. We don't have the resources to do those sorts of things. So just at the outset, I think it's important to say what those constraints are. Different courts have had different experiences with jury yield. And in our court in Los Angeles, our jury yield in terms of how many summonses we send out versus how many people respond at all, we usually have a yield rate of only 30%. 30%. It's now down to 11%. So
wow.
Yes, wow. But, we're working against a restriction, if you will, that already exists. And, if you want to, we can talk a little bit about what our usual methodologies are for enforcing jury summonses. But we have been doing a lot on our court website. Marketing even, we have a marketing tag which is called Here For You, Safe For You, and we spend a lot of time on the website and also in the online jury orientation, explaining to people the safety measures that they'll experience when they come into court. Again, each of the diverse experiences with trials that I'll talk about a little bit later, the judges reported that the people who did come in were very happy to serve. They were enthusiastic, indeed.
One of the remarkable things, I think, with the number that you just mentioned, that the regular yield is as low as 30% and that it's falling down to 11%, is that this is indicative of that COVID-19 is just putting pressure on the types of problems that we're already seeing in our jury system. The idea that many people aren't responding to summons, many people aren't reporting. And really one of the problems, I mean, there are many problems with that, but one of them is how much that affects juror diversity. Professor Hans, perhaps you could speak a little bit to that. We've touched on the importance of diversity, but when the court can't bring people in, what are the effects?
Well, so the strongest juries are the ones that represent the community at large, the broadest range from the community. Again, that really helps in fact-finding, the accuracy of fact-finding when some jurors might test and ask for further explanations of individuals who have made assumptions about the evidence that they're hearing. We actually have some interesting information about the challenges of assembling diverse juries from the National Center of State Courts project. They commissioned back in June an interesting national survey where they explored some of the issues that we're talking about in terms of people's willingness to serve, people's willingness to come to the courthouse, and actually also people's willingness to participate in virtual jury trials, which we'll talk about shortly. And it won't surprise you that people's willingness to come to the courthouse really did depend in part on some of their personal situations and personal characteristics. The least surprising is people who themselves had health issues or were living with people with serious health issues that could be affected if they became infected with COVID-19 were the most reluctant. There were also some differences in terms of the things we worry about on diversity grounds, the men versus women, older versus younger people, and race and ethnicity, so that whites as opposed to racial and ethnic minorities, men as opposed to women, and younger people as opposed to older people were all more likely to say anyway that they would respond. So I don't know if you've gotten a chance, Judge, to look at that 11%, but do you have a sense about whether or not you're able to get this same range of diversity in your jury pool now compared to the 30% yield that you were talking about before?
Well, we just don't have a lot of experience as yet, especially in my court. I spent some time talking to the federal court judge in San Diego who led the Ninth Circuit's COVID task force and his experience in his first trial, and talking to a judge in Alameda County, very fine practitioner, now judge, who conducted a civil trial there, a preference case, meaning that the plaintiff was within 6 months of dying. And then our supervising judge of our criminal courts in Los Angeles, all of whom conducted trials. And they each said that looking out at the people who appeared and who served on their jury, they did not see any difference now in terms of diversity. Now, I have to say, in Los Angeles, the diversity of any individual jury, by my observation, differs significantly from one case to another, and for reasons that I don't completely understand. But even in a normal time, you can get quite a bit of difference. You don't get the randomness in every particular jury, although we believe, and our very fine CEO, who's the jury commissioner of the court, believes that our processes do reach out at least to a diverse group and bring in a a group that is overall representative of our community. But the other thing was that in each of those different situations, the judges said that they did not see, once people came in, they did not see that there was any particular group that had hardships such that it was affecting the diversity of the veneer that actually served on the jury. Indeed, one of the judges said that the only people who were trying to get out of jury duty in the voir dire process were Caucasian males for whatever reason.
Bob Clifford, I'm so glad we were able to have you here with us today. I want to turn to you to see what your thoughts. I'm sorry.
Apologies to all for being late. I had a difficult time logging in.
No problem at all. Thank you so much for joining. I wanted to ask your opinion on what you've been seeing in the courts right now as a result of the pandemic. How has your practice been impacted by COVID-19?
Well, greetings to all from the Windy City. Our practice has been impacted dramatically. If you look at our practice on multiple fronts, the first is that in a case like the crash of Ethiopian Airlines Flight 302, I have the privilege of serving as lead counsel on that case, and it's pending in the Northern District of Illinois, where currently the courthouse itself is closed. But we have terrific access to our judges, and they've made themselves very available to us. But the however is that there are no jury trials. And the court has developed a plan that will, where they've taken over the ceremonial courtroom, that they've, jury rigging, if you will, where folks would sit and socially distance and the like. And one of the very hot topics for us that I brought up to counsel for Boeing just this past week was I want to make a motion to the court to get into the queue, because what we see happening is that there's limited availability to the facility. We don't anticipate a trial in that case before at the earliest the fall of next year, if not into the spring of 2022. But I want to get us into the queue because there's going to be a demand for that. So that's part one. At a lesser level, I mean, my office is, we have 25 lawyers, and we're a tort law practice. So we have medical malpractice, product liability, auto crash cases, and the like. And there are in the state court system here in Illinois, in some of the smaller counties, an effort being made to use literally a high school gym in one instance to set up a jury room. And so there's all that kind of tweaking going on. We do have, we just agreed to participate with State Farm in a pilot program to try some auto cases where the claim is below $50,000 in a virtual trial. But the elephant in the room, from my perspective, is the jury pool itself. And so, for an example, anecdotally, here in Cook County, Illinois, there was a call for grand jurors. They've sent out 400 subpoenas. 40 people showed up. So that's a number one problem. Number two, when you go to the virtual program, well, the diverse pool that we're used to in an area like Chicago, many of these folks don't have access to computers. They don't have the bandwidth of Wi-Fi. And well, that really skews the jury pool and doesn't make it reflective of the community. And there are grave concerns about that. And so, COVID is impacting things greatly. And then finally, I'll say, from the settlement negotiation perspective, I actually have had claims guys tell me and my colleagues Well, Bob, that's a fine demand for settlement. Let's talk about it. And by the way, how much of a COVID discount do you want to give us? That's going on in the real world in the trenches.
Yep.
Arturo,
Yeah.
please.
Yeah, let me follow up on that, Richard. That I really appreciate hearing Robert's experience. I think we need to lay the groundwork for the participants in this program to understand what's going on nationally, because that was a great example of what's happening in Illinois. It's happening everywhere. I mean, to put this in context, in a normal year, pre-COVID, you can walk into almost any courthouse anywhere in America, and if you just walk from courtroom to courtroom, ultimately you'll run into a jury trial, a criminal trial, maybe a civil trial. That all stopped at the end of March. And not everybody stopped at the same time. But at the end of March, it all came to a halt. We just couldn't have jury trials anymore. And in many cases, we haven't had jury trials for many months. I'll give you a couple of quick examples of how different parts of the country are dealing just with whether or not they can even have jury trials. In Atlanta, the federal courts announced on Tuesday they will not have any civil jury trials for the rest of the year. And that's not to say they're going to start in January. That's to say we know we can't start any sooner than January. Other jurisdictions in Pittsburgh, they're going to be starting on October 19th. They're going to try to pick juries in the large convention center that they have. That's their plan. And we'll see how that works out. That starts on October 19th. In Texas, the Western District of Texas, they're going to have their first civil jury trial since this all started back in March at some point this month. It's going to be a patent trial. We'll see how that works. We'll talk later about what protections people are putting into place. In Alameda County, Northern California, in Oakland, we had 3 asbestos trials in July. One case settled, one was a defense verdict. The other one I think may still be ongoing. But there are very, very few civil jury trials that are actually getting out. And there are issues that have come up in all of them that we'll discuss down the road. But that's what everyone needs to understand, is that we have been in a holding pattern for at least 6 months. And we're slowly starting to get out of it, but we're encountering challenges along the way, including, I just mentioned one. And just to give you an example, many of our courthouses are in multi-floor buildings. The federal court in San Francisco, 19 floors? Well, you can only have 2 people in an elevator. So things like that are slowing down the reopening of the courthouses, and there are challenges that the courts are working through as we speak.
You know, I have a question and I don't know the answer to. I like Bob Clifford's idea of getting in line for the ceremonial courtroom, because I think it preserves the amazing and beauty of the courthouses. Are we losing things by some of these creative, admittedly creative solutions, like moving to convention centers or other large public places? Because the courthouse really does have this symbolic value as a place that is a government building, a kind of historically, this is the place where people came to have their cases heard and to be respected and treated with dignity and treated with equality. And the architecture of the buildings, in a way, suggests grandeur and a kind of sober approach and an approach infused with law. So I do wonder, I like people looking for solutions so that actually we can get back to the business of running jury trials. But I do worry a bit about, are we losing something by moving outside the courtroom spaces and the courthouse?
Professor, let me respond to that. I mean, I certainly agree with you about that comment, but candidly, my clients are interested in resolution. And I get it that, the idea of standing in a courtroom and, in the well of the courtroom and making your arguments and all the advocacy that both sides advance, that's very valuable. But the fact remains that certainly in most of the litigation I do, that having a trial date matters. Ask any judge, and they will tell you that the single most important way to get lawyers to get real about their cases to say, guess what? On Monday, we're putting a jury in the box, and I don't care what you all are doing. So, you know, I hear you. I mean, one of my partners wants to take over McCormack Place. You know, during the height of the pandemic here, they set up, the Corps of Engineers set up a 3,000 bed temporary hospital in McCormack Place. And the notion is, well, we can do the same thing over there with a courtroom. The real problem becomes, though, the mechanics, as Arturo were saying a moment ago, you know, the mechanics of getting people to the facility, number one, managing their coming and going into the facility. And then my point that I tried to make early on is the diversity of the pool itself and what you're going to get. You know, the fact is there's a socioeconomic component of access to the internet and the access to transportation, and all these different things come into play, and those impact whether or not you're getting a jury pool that's reflective of the real community. And I think for one, you're really not going to get that, and it's a real problem for us all.
I'll jump in and ask about, we have a question from the audience to go back to a point that Bob made just a moment ago, and that I think would be helpful for our audience to understand the effects of this 6-month delay that we're experiencing. Bob, you mentioned a COVID discount very briefly. The idea that, well, perhaps you can speak to what you mean by that. In addition, to open up the conversation, just how are you responding to the notion that maybe there isn't? You say it's very important that we have a trial date, but you may not be getting one. How is that affecting you? And are you seeing changes in the private dispute resolution field? Are ADR capitalizing on this situation?
Well, I'll give you a real example. Just yesterday, I have a case that's scheduled for mediation on Monday and Tuesday, virtual mediation, and it involves a big insurer. I won't name the insurer, but it's one of the largest in the country. It involves a catastrophic injury to 8 individuals. The demand is in excess of $100 million. And the remark that was made to me yesterday by the lead claims guy is, by the way, Bob, how much of a COVID discount are you thinking about? Because you know as well as I do that you're at least a year away from a jury trial. That is a real-time example, and that has an impact. Part one. Part two, the mediation industry, the cottage industry. You know, I was on a program at Harvard many years ago, and this was at the front end of ADR. And someone said, "Well, what do you think about ADR?" And I said, "Well, if it's a euphemism for taking less money." And you know what? That's kind of true still today. And however, that said, I am surprised that mediation has become a very effective tool, at least in our community, for resolving some cases. And we've settled medical malpractice claims, auto claims, some contract disputes. I just had the privilege of working with Ken Feinberg and Judge Lane Phillips, who are the designated mediators in the Purdue bankruptcy mediation that Judge Drain has ordered, and it was very successful. In terms of the process of mediating all the claims in the Purdue bankruptcy. So, you know, yes, that is an industry that's on the march, and I think it's going to be for some time to come. But we still need jury trials, and in the absence of those, it benefits the payor more than it does those who would be collecting.
Let me just
Richard, that answered your question.
It did, Judge. Please, yes.
I was just going to say, I have been worried for some time about the impact of the private justice economy on the courts, particularly in the business sector, and whether the courts are becoming places, not of first resort, but of last resort, such that the public justice economy becomes something like what people feared the public schools would become some years ago, where those who could perhaps would take their children into a private school, and then where's the support for public schools? And we worry about that in terms of the ability to provide cost-effective dispute resolution by way of court decision-making, including jury decision-making. And certainly what I've heard from friends who are in the private justice economy, who are at the various ADR providers, they're advertising strongly. And part of their advertising right now is you can't count on the courts. The courts are not there for you. And it's very painful. And it may take further a trend that already had started. And kind of to come back to Valerie's point about, what are we losing in terms of using our court spaces in different ways. Just from my personal perspective, we have to do whatever it takes, whatever is necessary to keep justice moving forward. We experienced on our court a very severe recession in about 2013. We had to reduce our staff size by a quarter. And we said to our judges, if you have to take pen and pencil in order to record your rulings, in order to move forward adjudicating cases, that's what we're all going to do together. And I think that very much should be, and hopefully is, the attitude of the courts toward this pandemic. But everywhere we turn, we're in a box. So, and I don't want to get away from our discussion about ADR, but previously there was a reference to using large public facilities, convention centers, and so forth. Our CEO sent out a request. What public buildings could we use? Just wherever we could. But then we hit the other side of the box, which is we've got to have some level of security. And our sheriff's department, which provides security for us, said, we're not doing that. So the constraints are so severe.
Well, I guess I'm getting the answer to the question, which is the symbols of the courthouse are nice, but we've got to face the reality right before us, which is, what do we need to be able to move cases forward, especially jury trials, with all their specific needs and requirements, like the security issues you have raised, Judge?
This brings up, as we've kind of been talking about, how do we use the courthouses that we have, and how do we use them in a way to address this as a practical solution? We have a PowerPoint that I'm hoping we can put up, that Arturo put together, that collected some images from various courthouses. There might be some technical problems here, so please deal with us as we try to load up the PowerPoint. But hopefully you can see some of these practical solutions to using the courthouses we do have. Arturo, maybe you could walk us through, if you go to the next slide, and Arturo, if you could walk us through sort of what we're seeing here, and we can all comment on what we see.
Sure. First of all, I want to give a plug to Decision Quest. They actually took these photos and let me borrow them for this program, because I wanted to give you just an illustration of some of the things that are being done in some courtrooms to try to make things safe. In this photo of the Los Angeles Superior Court, you'll see, first of all, you can see the judge. You can't see the other lawyer. Everybody has a mask. That's one thing for sure. I know that politically, we don't all agree on whether or not you should be wearing a mask. In the courts, everybody in every jurisdiction that I've seen thus far has every participant, including employees, wearing masks. There'll be some better pictures later, but on the floor here, you can see some pink squares and some green squares. They've taken the time to go through and put green squares where you can sit in the audience. And where, as you know, in many trials, you bring the jurors in and you pack them in like sardines. You could have 8 people sitting in a bench. Here you've got at least 3 empty seats in between people, even in the audience. You can only have 2 people at counsel table, and there are glass partitions that have been put up in front of the court clerk and in front of the witness. You can see them here on the left and on the right. Again, to try to create distance between participants and to try to make the courtroom safe. I want to add a footnote here, Richard, real quick, before we go to the other pictures. The reason why this is so important, we're not going to be able to reopen unless we persuade people that it's safe to go to the courtroom. I'll give you a quick example. Judge Donato in the Northern District of California, a federal judge, had a trial going on when the pandemic happened and the courtroom shut down. He was right in the middle of a trial. He tried in July to restart the trial by bringing the jurors and everyone back. Now, there was a lot of concern about that. Have jurors forgotten what they heard? Well, it became a moot issue because at least 2 jurors said to the judge, respectfully, I'm not coming back. They just didn't feel safe. And that's why this is so important. You got to make people feel safe so that we get that 11% number, higher. And I think there'll be other photos that'll show some of what's been done in some courtrooms.
Yeah, if I could just jump in, that same National Center for State Courts survey, the vast majority of people who responded said they would feel more comfortable coming in if everybody was masked and if everybody did social distancing. So no matter what we think about mask wearing and social distancing outside the courthouse environment, in the courthouse environment, it seems essential.
This is interesting. This is a mask that some judges are starting to wear that ultimately I think they'll have witnesses
if we
wear
could go
as well.
back to that slide. Sorry, I didn't mean to interrupt. If we could, yeah, here we go.
Sure. One of the many issues that has arisen that we need to deal with is, the jurors have to make a decision about what they think about the credibility of the witness. And if the witness in the box is wearing a mask, it makes it a little bit harder. So this is one solution potentially, which is to have a mask where you can see part of the person's face, at least their mouth, and some judges are starting to use those in some jurisdictions. And if you go back to the prior slide, I wanted to point something else out. You see the numbers there. You can see a number 5, and you can see a couple of numbers in the jury box. You see a 1 and a 3 on the wall. This is the way some courts are having jury trials. They're spreading the jurors out so that they're even sitting in the gallery, because you can't have, the tradition is that you have 12 jurors in a state court case in California. If you're in federal court, you might have 8, but they're always sitting together, and we can't have that. So you see here some of the numbers in the wall, and where judges are trying to be creative and spreading jurors out so that people be safe. And if you can go back one more picture. I want to flag, here you go. This is the photo I wanted to show you about the floor. This is Los Angeles. You can see what they've done here, where if you're in the audience, you can only sit in one of the green spots, and the bailiff has been instructed to enforce that. And thus far, it hasn't been a problem because not that many people are all that eager to go to court, even to watch a trial right now. But that's what they're doing to try to make things safe.
Judge, I couldn't help but notice you've got a mask there.
I do. I just put my clear mask on.
There you go.
And, this is one of the reasons why we need to have programs like this, so that we can share information. I found out about these masks from Judge Tony Battaglia in the federal court in San Diego. We had not heard about them. And this is, as I understand it, FDA approved. And you can see it comes toward the face at the side. This is foam rubber at the bottom, foam rubber at the top here, and this is the best thing I've found yet. And even the court reporters are so grateful because it's so much easier for them when they can see the judge's lips moving and see the expression on the judge's face and know who's talking. So this is new to us, but we'll get to it in a little bit. But the federal district court was able to had the money to buy these for all of the jurors, and all of the witnesses in the trial the criminal trial that was conducted in San Diego.
One of the questions from the audience that just came in asks, are those clear masks, can they be cleaned or are they disposable, single use? And I think this it implicates both the importance of the masks, but also the resources constraints that courts are facing. Is this something that the courts would plans to reuse, or how are we going to, personal protective equipment is expensive, I think is part of that question as well.
So I went online and bought this with my own money. They cost about $3 a piece. You can only buy them in bulk. But the Southern District provided them, Southern District Federal Court provided them in California. My understanding is that they gave jurors one for the entire time of the trial. I may be mistaken. The website did not specifically say whether it was single use or not. I've been using it more than once, but I don't have any health authorities say so on that. As you can see, it doesn't fog up, which is pretty remarkable. But you can clean the inside of it with hand sanitizer or some other product.
But I doubt, Richard, that you reuse it, meaning use it with another juror, another trial. You give it to a juror and that's it. Nobody else is going to use that mask, is my guess.
Oh, for sure. No, you
Yeah.
you can't wash it that way and give it to somebody else. The question in my mind is whether it's appropriate to use for more than one day, but I have done so far.
Do we want to go to the next slide?
And here you go, another example of social distancing. This is one thing you could do with your jury. You can, instead of putting your jurors in the box, you put your jurors in the audience, and those numbers correspond to the juror number. And the red numbers, I think, either are alternate or they're where audience members are allowed to sit, or members of the courtroom team.
Yes, thank you so much for getting those pictures for us. I think it's really helpful for people to be able to see what practical solutions we're seeing the courts implement to maintain the social distancing and to ensure some level of safety. In addition to these types of practical solutions, we can also talk about what have actually happened as far as how the trials have been conducted. Judge, I understand that you've put together an outline, and if we can have that loaded as well, I think that this will be illuminating for our audience. So let's see, again, there might be technological issues here. I hope we can get this loaded.
Okay, that looks good. Let me just say as an introduction, knowing that this program was coming up, I made some efforts to reach out to judges that I know and that I knew were conducting trials. And so these are just three examples. And of course, Valerie, I want to be apologetic here because nobody's suggesting that this is statistically significant in any way. But there were three very different approaches, and I thought that it was very interesting. So just by way of introduction, Judge Tony Battaglia in the Federal District Court in the Southern District of California conducted a criminal trial, and he did what he called flipping the courtroom, so that the lawyers faced the gallery. So there were enough spaces in the gallery for the jurors to sit, not enough to conduct voir dire, but enough spaces for the jurors to sit during trial. And so he had the lawyers face the gallery and face the jurors. He had the podium turned around so that the witness testified from the podium with a high chair there so the witness could sit. And he told the jurors, don't worry about me. You got, your backs are to the judge. But he got a camera situated in the courtroom such that it was projecting the image of the witness and the lawyers And that went to an iPad on the judge's bench, which so he could monitor the proceedings in that way. If we could move down a little bit on that chart so that, no, the other direction, I should have said up, so that that's it. So the middle column, so the left column has to do with that trial. The middle column is a criminal trial, the first criminal trial in the LA Superior Court, which essentially was done with, we'll describe the voir dire in a minute, but the jurors, were sitting in the gallery and in the witness box because that was the only way to have enough seats in that courtroom. And then on the right is a civil trial in an asbestos case conducted in the Alameda Superior Court with the jurors on Zoom and ultimately the presentation of evidence on Zoom. Let me just say by way of introduction that in California, if a plaintiff dies before judgment is entered in a trial, they lose their ability to collect for pain and suffering. That is our substantive law. It places a great deal of pressure on courts to get those kinds of cases where a plaintiff is expected to die within 6 months, to get those cases to trial, because if you can't get a verdict, that plaintiff is going to lose a substantial amount of damages. Okay, so with that as background, I put several topic areas here just by way of comparison. In the middle column, we already talked about the LA Superior Court's usual yield of 30% in summoning jurors, and it was 10%, or I later, I think, clarified that was 11% the yield we're getting. In the left column, the Southern District Federal Court usually gets a 60% response rate, and they are now getting 50%. I didn't have a characterization for the Alameda Superior Court, but they said their yield was actually higher than usual. With respect to the diversity of the jury veneer, we talked about in each instance, it seemed normal to the judge who was observing, with the exception for LA Superior Court in the middle. We now have an automatic excuse for jurors age over 65. And so the judge did observe that there were fewer, as he put it, elderly people on the jury. I'm not sure over 65 is elderly to me anymore. Okay, how was voir dire conducted? So voir dire meaning, you bring in a large group of people. You can't just start with 12 folks. Because of preemptories and cause challenges and hardships, your veneer has to be much larger than that. So in San Diego, on the left side, they used a large jury assembly room that had an outdoor patio and started with 60 people socially distanced. And as we mentioned, all of the participants wore the clear masks that were provided by the court. So all 60 had the clear masks on from the start. In the middle column in LA, what we are doing is the jury commissioner is ordering jurors to appear in a particular courtroom rather than in a jury assembly room. The reason for that is we hope to be conducting enough trials such that there would not be enough jury assembly rooms available to conduct voir dire. And so for that trial, 15 prospective jurors would come in at a time. All of the participants wore opaque masks. The jurors were required to have masks come into the courthouse. Everyone is required to have an opaque mask to come into the courthouse unless there is some excuse for health reasons for that particular juror. The voir dire took 3 times the normal length of time because of only being able to bring in 15 at a time. And you can only get 15 in that courtroom because it's one of our larger courtrooms. So some of our courtrooms are just absolutely out of business in terms of, most of our courtrooms, frankly, are out of business in terms of being able to conduct jury trials because you don't have seats for 12, 14 usually with alternates. So on the right, the Zoom trial. So they brought them in Alameda County into a jury assembly room. They had very brief questionnaires with regard to hardship and the ability of the prospective juror to access technology at home. Of the 69 that were brought in the jury veneer, only 4 said they had no access. Now I said, well, this is Silicon Valley, right? But no, this is Alameda County. So that is something noteworthy. Again, Valerie, this is something we should be looking at here. How many people do have technology? So for those with access to technology at home, they were told that voir dire would continue via Zoom. The judge noted that the court had provided prospective jurors with the opportunity to complete a questionnaire online before they came in, but very few people did. But then the judge said, well, but then they found out there was a software issue, that you had to have a very recent upgrade of your ISO or whatever it is to be able to access it. Okay, all those things happen. So I mentioned earlier, and I'll just say very briefly, in all 3 cases, the judges felt that the reaction of the jury veneer during voir dire was very positive. In particular, the jurors in Los Angeles were asked, did they feel safe after all the COVID restrictions and protections were explained to them? And they said that they did feel safe. And in Los Angeles, there were only 3 jurors who said they had a COVID hardship, so to speak, perhaps someone at home who was vulnerable out of the 55. Okay, so if we can go to the next page then.
Can we maybe talk about the pretrial questionnaire at this moment? Yeah, I'm very interested in this use of questionnaires. I think it's really valuable. And maybe this is an innovation that even more courts will use in the future. So maybe a silver lining that might come out of this experiment. The idea of offering jurors the large veneer, the opportunity to fill out questionnaires, often reveals that people might have connections to the individuals in the case or otherwise have very specific biases, and others have hardships, maybe now more than ever. And maybe courts should be expanding their use of these pretrial questionnaires to avoid having to bring everybody into the courtroom at one time. I can appreciate lawyers wanting to actually see jurors up close before they exercise peremptory challenges and maybe even challenges for cause, some of them. So what about widespread use of questionnaires online, followed by a smaller group coming to the courthouse?
Yes, I think that's certainly one way to do it. And you do have to take into account the level of participation that the lawyers have in the process of determining hardship. But we frequently, even in normal times, we use questionnaires in various ways to try to get to the core questions about either hardship or excusal for cause very early in the voir dire process. So in the case of Alameda, what they did was they just had a very, very short questionnaire intended to determine whether somebody was going to claim a COVID hardship on the one hand, or whether they had the technology on the other hand. So that was a real sort of rifle shot use of the questionnaire. And the other use of the questionnaire, and we use them frequently in our complex civil litigation courts. We almost always use them for trial, where you get a very extensive questionnaire. But then for an extensive questionnaire, you've got to have places for jurors to sit and be able to spend time. The Alameda County desire was to get them in, figure out who could appear remotely, and then let those people start appearing remotely.
Judge and one of the things that I think will change in the future, and maybe a real positive contribution that the organizers and sponsors of programs like this could do, is to develop and promote a uniform, subject to tweaking here and there, questionnaire. We're seeing questionnaires on the rise in at least in Illinois and the federal courts here and the state court, and by agreement. And you talk about the changes that are going to occur in a COVID era. I think questionnaires are going to become the norm as opposed to the exception. And I've looked at a lot of different questionnaires from around the country in order to develop some for use in given cases over the last 12 months. And there's some uniformity, maybe at the 60 percentile, 70 percentile, but then, there's differences that, you'll get a good idea from Arizona and you'll get a good idea from Texas and California and Illinois. Maybe that's something this group could sponsor.
So just,
yeah, I think that's a great idea, and we'll have to talk about that. I mean, one of the questions I have though about a standard questionnaire is, wouldn't you want sets of questions for particular kinds of cases, like torts cases, I don't know, products cases, contracts cases, but that could also be part of a standard set of options for individuals. But I do like hearing that questionnaires are on the rise, because you can see in this difficult moment where we want to try to avoid bringing lots of people into the courtroom, being able to have people fill out questionnaires in their own homes, or perhaps, via some online mechanism would really help cut down the number of people who have to show up at the courthouse.
So, Valerie, can I jump in here just for 1 second on this questionnaire point? I think it's an excellent point. I think I'm agreeing here that I think it's something that's going to stick with us. I don't think we're going to see the same type of cattle calls that we are accustomed to seeing, where 150 people show up. The value of a questionnaire, and it doesn't have to be long. We can get this, I'm with Bob, we can get this to 1 page. The value of a questionnaire is that it helps you identify a number of people who cannot possibly serve on a jury. And there's no reason for them to come, drive an hour or half an hour, whatever it is, find a place to park, get into the jury room, wait around half a day, and then finally get called into a courtroom, and then have to explain to a judge this issue that they could have put in a questionnaire. There are tons of examples. You can take somebody, maybe a working parent, has 3 children, is the only breadwinner. If I don't work, I can't pay the rent. That person's not going to sit on a jury, and we don't need that person to go through all of these, logistics to get to that point. We can do that by questionnaire, and I also think that you can have a spot for the court to add a couple of questions that are particular to that case. If you're representing an HMO, you may want to put a question in there. Do you have any strong feelings about HMOs? And if somebody says, well, yeah, they've killed my parents because they didn't give them the medical care they needed because they couldn't pay, that person's probably not going to serve. Don't need to bring that person in. So I do think that's one of the permanent changes that's going to happen, is that in order to prevent 150 people from coming in, we've got to get to the point where we can communicate with people electronically. I know we have people's addresses. The problem is we don't have people's emails. We have to figure out a way to get these questionnaires to people as efficiently as possible. Electronic would be best. And then that would eliminate, I think, the need for many of them to come into court.
So just to move ahead here, so that we can have kind of an overall discussion. So I mentioned the presentation of evidence methodology in the Southern District of California, where they flipped the courtroom. I would encourage anybody who's interested in this, because I thought it was fascinating. On the website for the Federal Bar Association for the Southern District of California, they have a demonstration video of how this worked, how they flipped the courtroom and how the presentation of evidence worked. So in the middle column in Los Angeles, everybody wore opaque masks. No counsel objected to testimony by witnesses with opaque masks, and the jurors also wore opaque masks. Jurors were seated both in the jury box and in the gallery. On the right-hand column in the Zoom trial, their initial concept was that the presentation of evidence would be in the courtroom with the jury on Zoom. They had some technical problems, and so they went to presentations completely. Everybody was appearing via Zoom. They assigned one court staff person to do nothing but watch the jurors to make sure that they paid attention. With respect to arrangements in the courthouse, those trials where the jurors were in the courthouse, in federal court, they sequestered the jurors from 9 to 5 and fed them lunch and snacks and coffee. The judges, in order to maintain social distancing in the hallways, limited the number of trials that they were doing to, I forget whether it was 1 or 2 per floor. In Los Angeles, they didn't have the wherewithal to feed the jurors, so the jurors came and went. It is a 19-story building. The jurors complained about delays and with the elevators, and by definition, you're going to have to give people longer breaks because to use the facilities, they can't be crowded. And then on the Zoom trial, they didn't need special arrangements in the courthouse after the initial voir dire. They did have some issues about juror attention, and the judge said his favorite objection was objection, juror number 3 has a cat on her lap. So things did happen. So let me just quickly mention jury deliberations. This is actually one of the most challenging aspects with regard to facilities, because if you think of what a jury room looks like, if you've ever seen one, it has a conference table in it for 12 people. That does not work. And so both in San Diego and in Los Angeles, the only solution worked out was to dedicate an entire courtroom to the jury deliberations and close that courtroom to all other business during the time of jury deliberations. And I will tell you, we have thought and thought, and we have not been able to find any other way to deal with that. So an entire courtroom is devoted to jury deliberations during that time. On the Zoom, the deliberations were in a dedicated room. On Zoom, they delivered copies of the exhibits, the jury instructions, and the verdict form in hard copy to the homes of the deliberating jurors. And then public access. This is another very important but very difficult point. What are you going to do with public access? So in federal court in San Diego, they made another courtroom available full-time for the press and public and had a video feed into that courtroom. And again, you've got to have the facilities and the ability to, set up video in that way. In LA, what we've done is set aside 2 seats, one for media and the public in courtrooms. So again, that diminishes the number of courtrooms that are able to have jury trials. And then with respect to the Alameda trial, they had an audio broadcast from the court website. And they have that for all their hearings and for trial, just as an audio broadcast. And then I guess they could, if there was a press person, they could have granted right to access to Zoom by invitation and password. So anyway, those were the points I thought that were important and interesting by way of comparison with those 3 experiences.
It's incredibly informative, and I'm so happy that we can use these examples to launch a discussion into the use of technology, particularly Zoom and these ideas of virtual trials, either partial through conducting some level of voir dire through a virtual means, or perhaps full jury trials. I'm curious to hear from Arturo and Bob first, just from a practical point of view. Would you ever agree to conduct a trial via Zoom? Perhaps down the line, after we have more experiments or more data on this, but just right now, if your client came to you and said, look, I want to bring this thing to trial. It's going to be 1.5 years. I don't want to pay. I don't want a COVID discount. I want to go to trial. And you say, all right, we'll do it virtually. Would you guys do that?
We've talked about that. And the answer for me at the moment is no. We think that we think the best strategy for our clients at the moment is to allow a little experimentation to go on here. We've looked at a variety of different ideas. I mean, we're talking more about bench trials. We're talking about binding mediation. We're talking about 3-panel mediators with a recommendation, that's not binding. So we're trying to find a lot of ways to skin the cat, if you will, not the cat that's sitting on that lady's lap. But it's going to be a little bit down the line for us, because I really appreciated hearing what Judge presented by way of the diversity that they experienced and the percentage of folks that showed up. That's just not the experience that we think is taking place in Chicago at the moment. So maybe it's regional specific or city specific, but right now we explain to our clients, these are words that we've used over the last 2 weeks with clients. Listen, you need to stick around for the long haul. This is a process, not an event. Let this unfold. Let the court catch up. Chicago, Cook County is one of the largest court systems in America. People are afraid here. Both courthouses are closed, and yet we have terrific judges who are begging for work. And that's where one of the concepts that's being thrown around right now is, okay, give us 3 judges out of the law division, and let's take an experiment here. Let's have a non-binding trial in front of those folks. And I say non-binding because it's, you're giving up the right to trial by jury. And that's an important right. But maybe we could all get a little comfortable with that. And we'll see. So I'm sorry for the long-winded answer, but that is how we feel.
So Bob Clifford, you mentioned earlier that you're doing a pilot experiment with State Farm
Yes.
for lower dollar value auto cases. Is that going to be with judges and non-binding?
Oh yeah. No, it's going to be with judge. It's with a judge, or Lorna Probst, Judge Probst, well known to many of you, I think. And it's going to be a virtual trial with a jury, and it's going to be a jury trial.
Oh, it will be a jury trial. Oh, well, I urge you to take, study it systematically. That sounds like it could be, not only important for you in your practice, but also really important for people across the country to understand, what happens in a virtual jury trial. So kudos to you for your willingness to do that.
So Richard, your question is quite timely. I had a matter that's set for trial starting Monday after Thanksgiving. And the judge has told us that if we want to keep that trial date, it has to be a bench trial. So we need to make a decision. Do we want a bench trial, or do we want to lose our date? In another case, a judge has told us that we have a trial set at the very end of the year, but if it goes, it's going to have to be a virtual trial. And so the exact question you're asking is the exact question that we're currently contemplating. We haven't answered either one of those, but I want to just mention very briefly 2 very real and practical examples of the sorts of things that can happen that we need to learn from. Everybody, I think, knows that in a real jury trial, you're not allowed to talk to the jurors. Even if you see them in the hallway, you're not allowed to say, how's your morning going? You're supposed to keep your distance. We don't want there to be any appearance of impropriety. I have a rule for my trial teams. If a juror goes into an elevator, we wait for the next elevator for that reason. What happened in the Alameda trial was the judge was talking to the lawyers for some reason on some issue. And the jurors remained on the screen with the plaintiff. They were all on the screen. And as you can see my background, I have a virtual background. And the plaintiff noticed that some of the jurors had virtual backgrounds and asked them about it. And they started talking about virtual backgrounds and how do I do it? And the jurors taught the plaintiff how to do it. Now, that may sound innocent enough, but obviously completely inappropriate. So we need to figure out a way to make sure the jurors can never communicate, obviously, with anyone. There's got to be a way to mute everybody out. Second thing I want to mention, again, in terms of practical issues that have come up, we had a 3-day hearing on a motion for preliminary injunction. And And during the second day of that hearing, we got Zoom bombed. And look, I'd never heard of Zoom before the end of March, and I certainly had not heard of Zoom bombing. But on the second day of this hearing in federal court, all of a sudden, pornography, the Nazi swastika, and some Arabic writing appeared on the screen. Boom. And it sat there for 5 minutes until the clerk could figure out how to remove it. And then what happened for the rest of the trial, because with the trial with witnesses testifying, is that the court no longer allowed anyone to control what appeared on the screen except for the court clerk. That complicated things, because if you want to put an exhibit up, now you had to tell the clerk to put the exhibit up where you had prepared with your own techie to do it. So anyway, I cite those as two practical examples of the sort of thing we need to work on. There will be glitches, there will be issues, but we need to figure this out.
As we try to move forward and test the Zoom trials and how fair they are, Valerie, you noted how important it is that we start collecting this data. We have experiments going on around the country. And one of the questions from our audience was, are there these types of objective tests going on? Do we see, are there studies happening right now? And the question specifically was, what would we need to know? What type of data would we want? And I think this implicates everybody in the discussion. What information would you want to know about these experiments? So Professor Hans, maybe you could speak to, have you seen anything going on? Is there anybody who's leading this charge?
I think there are some projects getting started right now. It is actually scientifically a really challenging issue. The kind of pilot that Bob Clifford was talking about with real juries is going to be very informative and very valuable. We could also study these kinds of questions in the research laboratory using experiments where half of the people participate in some version of a real event and the other half some version of a videotaped virtual event. So those are some of the techniques that might be able to be used. Real world experiences around the kind as different jurisdictions are trying out virtual trials and in-person trials, kind of like the judge's forum, right? That contrasted the different sorts of things. So we get that information and then some experimentation. I think that's the way to go. The things I would want to look at, one thing you probably will study best in the real world cases is how it affects who shows up for jury trial. And whether or not the digital divide limits the participation of some people in a way that is more egregious or less egregious than what happens right now in terms of who will show up for jury duty. But there's another issue too, and that's the impact of the testimony on fact finders. And some experiments in other domains have suggested that when you see things virtually, they may not have quite as strong an emotional impact as when you see them in person. And Zoom experiences are especially intriguing in this regard because, one of the ways that we might feel the emotion somebody else is reporting or the pain and injury from an accident, for example, is by having eye contact with them. And that doesn't really happen on Zoom. There's a lot of asymmetry. Excuse me. A lot of asymmetry. So I'd want to look at how the testimony comes across to people and whether or not that affects their decision making at all.
Would the other panelists agree that it's not just the technological shortcomings that might be involved with Zoom, but that this kind of goes back to something we were talking about at the beginning, the grandeur of the courtroom, when you lose out on that, when you lose out on eye contact, when you lose out on that personal feel. Perhaps even deliberations taking place virtually aren't going to have the same impact or the same level of contentiousness or consensus building. However we want to describe that process, if we think that it's possible over Zoom. Is that something critical that we need to be looking at before everyone here would say, yes, let's start using Zoom trials, perhaps even after the pandemic is better?
Well, I think you need to recognize what you're giving up. I mean, look, and I think it was Valerie who talked about this, putting aside the grandeur of the courtroom, if you will, one of the things that I was reflecting on it as she was talking is that I can point to instances, and I'm sure Arturo could as well, where you're sitting in the courtroom and you see a juror walk into the jury box from the audience into the box, and you notice something about them, whether it's a tattoo or a limp or a something or another. They smile at your opponent, whatever. It doesn't matter. You're losing that, and you're never going to recapture that, and that matters. And you're never going to get it back. So you just have to recognize that, yes, we might be accommodating the case going forward, but you are giving some things up when you do that.
Yeah, you definitely are. I'll give you another example in addition to what Bob mentioned. I'm always interested in books. Jurors will frequently come into the courtrooms with books because they know there's going to be a lot of waiting time. I'm always interested in what is that juror reading. That tells me something about the juror, and you do lose that. I don't think there's anything better than being live and in person. One other thing I'll mention that's a little bit of a concern to me: it's hard enough to keep the jurors attentive and awake when they're in the courtroom. I mean, I've seen more than one juror doze off. I mean, it's hard enough when they're in the courtroom, but when they're at home, I don't know if people caught this, but the jury trial that was in Oakland and Alameda County that was on the judge's chart, the jurors were never in the courtroom. They were at home. And so they're at home watching the trial, and who knows what distractions are going around. I love the cat story because that's exactly my point. You've got pets, you've got children, maybe somebody's watching TV at the same time. Who knows? So I want to make sure that we have the attention of the jurors. And I think the jury is still out on whether or not you actually get their attention when they're at home. That does concern me a little bit.
Judge, maybe you could speak to this. Are courts going to, as we keep experimenting with these types of virtual trials, not just technological issues of Zoom and making sure everybody can get access, but maybe not making sure there aren't cats on the lap, but procedures maybe for us to try to at least make it to address some of those problems?
So a lot really, with respect to virtual testimony, a lot is really happening in the deposition sphere. So pretty much in my complex litigation cases, pretty much all of the depositions are being conducted by a remote platform. And the first question was, well, what are the ground rules going to be for this? And very quickly, ground rules have been created. Everybody's gotten used to them. And when I say ground rules, one of them, for example, is that the lawyer representing the witness cannot communicate with the witness while the witness is testifying and has to wait until there's a break. And then they set up whether that communication can take place by phone or text or what can happen. The ability of the witness to see the entirety of a document and not just what the lawyer is putting up on the screen. But that has been overcome. I've witnessed some of these depositions because we offer to lawyers that if they're having this in complex litigation, if they're having problems that in ordinary times, I would get on the phone and try and help them. Now I just zoom in. And it takes a bit longer, and counsel is going to be, Arturo and Robert are going to be able to tell us it takes a bit longer to do those depositions. But I've been very impressed with that process, and people are getting used to it, no question about it.
One of the intriguing questions we just received, and I want to encourage the audience again as we're reaching the end of our discussion to be submitting questions. But this is a rather intriguing question, so I'm curious to hear everyone's thoughts on this. Arturo and Bob, you both mentioned sort of your reliance on certain pieces of information to help decide whether or not you want to keep a juror or strike a juror. And you noted perhaps a limp or a tattoo or a book. And some might argue that those are the types of factors that are perhaps irrelevant. And perhaps not having that information allows us to not maybe draw upon implicit bias and maybe create an even better jury. This is the question that's been posed. So do some on this panel think that, yes, robbing ourselves of certain pieces of information might create a better body. Of course, you might note that we're given new pieces of information about them. We might see the fact that they have something in their background in their Zoom, or perhaps we can tell something by the technological divide again. So what are people's thoughts on the type of information we lose out on and the type of information we maybe gain on the jurors through virtual jury trial and virtual jury selection?
Well, I certainly have a view, but I'll wait for others to weigh in.
I was waiting for Bob.
Yeah.
Look, let me just say this briefly, because I know we're running short on time. I believe in getting as much information as possible about jurors. Let's face it, experienced trial lawyers have teams of people who go out in social media to try to get information about jurors that's publicly available, only publicly available information. So I want to know as much as possible about the jury. If I'm in a civil rights case and somebody's got a book that says, police officers' Bill of Rights, okay, I'm interested in that. So I get the question. It's a fair question, but I want to get as much information as I can about these jurors.
Well said. Nothing to add.
Well, so that as we keep talking about this type of information, I've got another great question from the audience asking, there are so many experiments going on with these remote trials and so much that can go wrong. I don't know if a cat on the lap could be used for a motion for a mistrial, but we can imagine situations that might be. I'm curious, is part of the agreement to enter into this waiving certain rights for claims of mistrial? What type of discussions are we seeing the parties enter into prior to engaging in these experiments? And out of curiosity, what do you guys think would be grounds for saying a mistrial? And what do you think are just sort of par for the course as we muddle through these experiments?
Well, let me go to the one case that we've been talking about, the State Farm matter. And those are real questions. I mean, just yesterday, I'm on a Zoom call, and one of the lawyers in the call, next thing I know, her daughter's sitting on her lap. Her son was running around the background, and the husband walked past. Now, we're all talking about stuff that's privileged. I mean, so juxtaposition that to a jury trial. These things are going to happen. And yet I draw it, the analogy I draw is to, and I'm sure the judges on the program today and listening have had this, where something happens with the jury afterwards. The jury, maybe a juror didn't answer a question correctly, or didn't say, oh, by the way, I forgot that guy's law firm represented my uncle or my brother or my husband at one time, those kind of things. And where you bring the juror in to chambers with all counsel, and the judge inquires about bias and prejudice and the like, and then ultimately makes a decision about whether or not that can attack the jury verdict. Those kind of things are going to happen, and we have to recognize that we're in a brave new world.
I think
it's the goose gander rule. It's going to happen to me one day where I'm in trouble about it, and it's going to happen to Arturo one day that he's got a problem about it.
Yeah, and I think, Richard, the trial in Alameda County, the defendant objected to the procedure and the process. And so it's a very good question. It'd be great if you can get the parties to agree on a set of ground rules. And I think that is something very important going forward, is we got to try to come up with ground rules that we can recommend the parties can agree to. But currently, there isn't a set of ground rules that everybody's agreed to. And I think people are preserving their rights to see how this plays out.
We've been talking about some of the problems with virtual trials and trials that are, available for viewing and everything. There's an interesting result of Texas's decision to place many of its trials on YouTube, and one of the things that's happened is thousands of people are following these trials. It's a real fascinating moment. If you think about, our grand courtrooms are actually only available to people in very small regional areas for the most part. And one of the benefits of moving at least some of our litigation to the virtual world is greater accessibility. So I'll end on that.
Richard,
I really can't thank everybody enough here. We are running out of time, and I just want to thank everybody for this fascinating and illuminating discussion. I want to thank the audience for submitting such fantastic questions. I really think that we learned a lot today, and I have a lot of questions that I'm excited to go forth and look at, and hopefully we can do some research and figure out what is working, what isn't working, so that we can make sure that civil jury trials continue. Judge Kuhl, Arturo Gonzalez, Professor Hans, and Bob Clifford, I really want to thank you again. And to the audience, I want to let you know that we will be taking a short break between the panels. So as we sign off, there will be a brief break right now while the screen will go pretty blank for just a moment while the next panel gets set up. After that panel, we will end up having a lunch break where the Zoom will completely shut down, and we ask you to sign back in afterward. There will then be another similar 10-minute break between the third and fourth panel. So please hold on for just a bit, and we'll get the next panel up and going for you. Thank you again, everyone.